Second half of the presentation is equally outstanding. It's Dan Hanlon from the Rensselaer County District Attorney's Office. And Dan's going to talk about search warrant procedure. It's a wonderful presentation. Let me read you some information about Dan. In a nutshell, Dan Hanlon is the Chief Assistant District Attorney in the DA's office. That means he is Trish DeAngelis' second in command, her right-hand man. Dan has been a prosecutor for 10 years, and he began working in the DA's office right out of law school. He has prosecuted every kind of case out there and specialized in drug cases as the bureau chief of the drug unit for many years. He's a special assistant U.S. attorney handling federal drug and gun cases for the U.S. Attorney's Office. He has successfully prosecuted some of the county's most notorious criminals, including the Christopher Drabek homicide, a confidential informant murdered in Lansingburg days before he was to testify in Albany County Court. Dan worked for 2 years to seal the conviction against all 3 defendants in that case, and all those 3 defendants are now serving life sentences. Dan has trained law enforcement officers and prosecutors throughout New York State and has a specialty in search and seizure law in New York State. Most importantly, Dan is the proud father of a Maltese puppy named Dugan. Trish wrote the bio.
Can everyone hear me all right? Is this working? All right. I also have 2 daughters. Trish didn't mention that. And I do prosecute violent defendants, so I like to introduce the Maltese as my wife's dog, so maybe we'll switch that in the bio from now on. It's a small, white, fluffy dog if you don't know what a Maltese is. I have a presentation, as you see. I'll get to that in a minute, but first I want to talk about, and I won't stand at this podium the whole time either, but I do want to talk about a couple of things that Sue brought up. And one of them, I guess the best way to start this presentation, my presentation, is to mention that the press was here. I think all the news stations were here, if not most of them. Those of you that work these kind of cases, and even those of you who don't, recognize the fact that these cases are under a microscope. If I was presenting a lecture on how to prosecute drug cases, no member of the press would be here. If you have 3 stories on your 6 o'clock news, one of them's a robbery at a convenience store, one of them's a shooting in downtown Troy, and one of them's an animal abuse case or an animal neglect case, what case is the top story? It's this, right? This topic is something that, and it's a top story because our community doesn't tolerate it. That's just clear. This topic is something that the people are going to pay attention to. And for whatever reason, they are very, very vocal. My introduction into the world of animal cruelty came, actually, those of you that have been in this field know Joel Ablove. He was a prosecutor with the Rensselaer County DA's office and did a lot of work, and was actually an expert in animal cruelty cases. I had to cover an arraignment for him on one of the first Buster Law cases. And at that time, I really had no idea. I hadn't ever prosecuted an animal cruelty case before, and I had no idea the scope of the interest in those types of cases. I was just there to cover an arraignment. It wasn't my case. I came out of the courtroom, and every camera from around the area was there, wanting to ask me questions about this case. And maybe some of you have already noticed I have a little bit of a nervous smile when I get up and public speak. It's not because I think anything's funny. It's just there. I can't help it. Well, the calls that my office got saying that I wasn't taking that case seriously because of that smile, you wouldn't believe. People do not tolerate people not taking these cases seriously. So we're under a microscope. I guess that whole recitation is meant to point that out. So we want to do everything right. We've got to do everything right. And when you as police officers are investigating these crimes, what we always hope, not just with animal cruelty cases, but also with any case, what we're always hoping for is that you're keeping the end in mind. Obviously, it doesn't end with the arrest, this investigation. It ends when the offender goes to prison or jail or gets whatever punishment that person deserves. That's when it ends. And for it to end that successfully, we've got to be able to prosecute it. We've got to have a strong case to prosecute. So that's why I guess I'm here. I'm here to talk about search and seizure issues, talk about search warrants, because the majority of cases that we're talking about are going to involve getting a search warrant. And not only are a lot of police officers, as Sue McDonough mentioned, a lot of police officers aren't familiar with this area of the law. I have to admit that there are a lot of prosecutors, not just in my office but everywhere, who also have very little knowledge in this area. They haven't prosecuted many of these cases. it's a good idea, if there are prosecutors in the room, to designate someone who has an interest in these cases. Everyone should prosecute them, but if you've got someone who's designated to become an expert, that's always good to have, whether you're a police department or whether you're a DA's office. I'm not an expert in animal cruelty cases. My eyes have been opened. I've got to tell you, it's a good thing to see someone like Sue McDonough talk about these cases. You recognize all the implications. Even if you're not an animal activist or an animal lover, you see that there are other implications involved in these cases that go well beyond just the animals. You're going to see that they invoke, situations of child abuse. You're going to see that they invoke evidence that this person has a violent capability and not just against animals. You're going to see elderly people who may not intentionally be neglecting animals, but because of their own situation are neglecting the animals and themselves. The types of things that these can branch into are, you just can't really measure them. So they're important, and maybe that's why the press is here, okay? So let's talk about this, the crime scene. I love Sue's presentation. I saw it yesterday too, I saw it today. It was just as fresh today as it was yesterday for me. Those pictures she put up, I can't stress enough how important it is to have people who know what they're doing at these crime scenes. When you do an animal abuse case, an animal neglect case, especially some of these cases where you're involving not necessarily domesticated animals, or if my terminology is incorrect, companion animals, what about the farm animals? You have got to have a plan before you get that search warrant signed. You've got to have people designated to do certain things, and they all have to know what they're doing. And police officers in these cases need help from people who are not police officers, right? Obviously. Now here's the catch with that. Someone like me, who's not familiar with these cases, or many of you who are police officers, are uncomfortable with bringing civilians onto a crime scene or assisting you with a search warrant, because we're not used to doing that. The CPL, or the Criminal Procedure Law, does not provide for anyone other than a police officer to apply for a search warrant or to execute a search warrant. There is nothing in the Criminal Procedure Law that allows for civilians to assist police officers to execute a search warrant. But that does not mean that you can't, and this is where we have to get this message out. You can have people who are expert in the field, veterinarians, SPCA, Mohawk, Hudson Mohawk, that's the treatment center, I'm sorry, the Humane Society. You can have those individuals who have an expertise in this field help you. You just have to remember that they are your agents. And again, I'm speaking to the police officers in this crowd. What they do, you will be held responsible for. They are acting with their expertise, but they are acting as your agents, police agents. So you've got to make sure you know what they're doing, and you've got to designate them to do only what they're there to do. A crime scene is something that has to be treated very carefully, no matter what kind of case it is. So, those pictures, going back to those pictures that were put up. The horse, for example, you had an individual holding onto the horse. What I liked about that, in some of those pictures, in a lot of those pictures actually, you don't even see the face of the handler. In many instances, you don't even see the handler. That's good, because you don't want them to distract from what the actual evidence is. You have to have someone who's taking these pictures who recognizes that it's not just the evidence you're taking a picture of. That's not all the jury's going to see. What they're going to see is what's in the frame. So you don't want extraneous material, distracting material, inappropriate material in that frame. For example, and I bring these examples up because they've actually happened. I've seen them happen. They're certainly not willful. They're not intentional misdeeds, but they happen. If you go to a search warrant and you're a civilian or even a police officer who's not in uniform, you may not necessarily be dressed professionally. I've seen cases in drug cases where a narcotics investigator went to a search warrant with a South Park t-shirt on, and there's a big Cartman on the front of his shirt. That's okay. You're not necessarily expecting to have to wear a suit to these things, especially under certain circumstances if you're going onto a farm. But bear in mind that you do not want Cartman in your photographs, right? You don't want them in your pictures. So you've got to have people who are cognizant of that. It's an easy thing to miss, not just with pictures, with video. Much more important with video. When you're on a crime scene, as I'm sure you're all aware, juries, especially these days, don't want to hear it. They want to see it. You know what I'm saying? Pictures and video. So if you've got someone taking video, make sure it's someone who's done it before, who knows what they're doing, who knows what not to do For example, as you're taking the video, you might catch by accident 2 officers not involved in anything at the time. Maybe they were the officers that made entry into the house or the residence, or helped, arrest. Their sole job is to arrest suspects. They're not collecting evidence. But what if the video captures them joking with each other and laughing? It's not meant to demean or belittle what's going on in that scene, but there are jurors who will perceive it that way. If they see people who are police officers. And make no mistake, if the jurors missed it or didn't think much of it, the defense attorney will make sure that they haven't missed it and they will make something of it. So these are things you've got to remember. More in these cases than with most cases, because not only do you have the scrutiny of the public, a lot of times the media will be right on the scene. Believe me, if they hear that you're conducting a search warrant somehow at any of these crime scenes involving animal neglect or animal abuse, they will be there. And it's going to be your job as police officers to expand that crime scene enough so that they don't get where they're not supposed to be. I mentioned you can bring civilians in with you, to assist you. That does not include the press. I know these are hot topic cases, but the press should not be there on the crime scene as you're conducting the search. If it were up to me, as the person selfishly who has to handle this case in the future, I would prefer the press not be given anything. And I know that's not realistic necessarily because you want to make this public, but it can hurt the case. If police officers or Humane Society representatives or SPCA or veterinarians are on the scene, they are agents of the police. And if they're interviewed by members of the media, what they say can come and bite me in the rear end down the road. Personal feelings especially. This has to be kept professional. As much as you may be disgusted with what you see, that's not something necessarily you should be telling the press. You can certainly feel that way. You can tell your friends that. You can tell your colleagues that. But if you tell the press that, then you're no longer an unbiased participant. You're no longer just a cool professional law enforcement officer or agent. You are now someone who's got an axe to grind or something like that. That's the way it's going to be perceived. And I know it may not be fair, but this is the reality. These cases, when you get animal cruelty cases, as Sue mentioned, and it couldn't be more true, not only do they not want to give up their animals, I've had this over and over, it happens over and over. They neglect these animals, and for whatever reason, they hold on to them for dear life when they get arrested. It's disgusting, it's deplorable, but it seems to happen in every case. Well, not only do they fight giving up their animals, they don't want to plead guilty. They want to take these cases to trial. They're stubborn. Think of the type of people you're dealing with. The type of people who do this aren't the brightest people in the world, for one thing. They don't necessarily want to listen to their attorneys. They want to go all the way to trial, and they want to tell the jury that they didn't do anything wrong. So, what does that mean for me? It means I hope that I have a very strong case, because I'm not going to get away with pleading this guilty most of the time. Most of the time, we have to take it at least through the suppression hearing. And the suppression hearing is when we're going to get to this. Suppression hearing deals with when you seize those animals or that evidence, were you seizing it legally? And it's got to be legal. Remember also, and this is a point, I don't mean to offend anybody, because most of the people that assist law enforcement that are civilians on these search warrant scenes are doing it for the right reasons. Not only most of them, all of them are. You guys all have good intentions in mind, but what you're not necessarily thinking about is what implications your own actions may have down the road. If you're assisting on a crime scene, there's a decent chance you will be called to testify as a witness down the road. There are plenty of people out there who do not want to have anything to do with a courtroom. They do not want to do any kind of public speaking. They do not want to be identified as someone who's assisting in arresting or getting this defendant arrested. They want to help the animals, and that's great, but they don't want to go any further than that. That's something that we need to be made aware of. Because what I want as a selfish prosecutor is someone who is not only willing to testify, but who is articulate, who is professional. If you have a nose ring or you wear crazy clothes, that's fine. I have no problem with that. Just don't do it in the courtroom, because juries don't tolerate it. And it's not necessarily a nice thing to say, but again, it's the reality. So we always have to do these types of things with the end result in mind, getting the suspects the punishment they deserve. Okay. Now we'll turn to the boring part. Fourth Amendment, it's been up there for a while, right? This is the pesky part of the Constitution, the amendment to the Constitution, that gets us into so much trouble. And I'll start by saying, if you don't already know, and every police officer in this room does know this, the courts in this state and pretty much in the country don't, when you compare how much they care about defendants' rights to how much they care about victims' rights, you get sick. It's not the victims necessarily that the courts are looking after. It's the defendants' rights. So you've got to keep that in mind. Are we violating the defendants' rights? And this is an important thing. It's the Fourth Amendment. It's so simple if you read it. There's nothing complicated about it. You can't, well, read it. There's the right of people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures shall not be violated. And no warrants shall be issued but upon probable cause, supported by oath or affirmation, particularly describing the place to be searched and the person or things to be seized. That's one sentence, and from that sentence comes thousands and thousands of cases regarding search and seizure, comes a whole section in the criminal procedure law. What the courts will not tolerate is an unreasonable search of a person. So how do we make sure that it's reasonable? Well, before I get to that, if it is unreasonable, if the search is held to be unreasonable, this is what happens. The evidence gets excluded. And for you police in the room, look at what you're up against. Judge Cardoza, 20s, 30s, and 40s, 1920s, 30s, and 40s, he was started out as a Court of Appeals judge. He got all the way to the Chief Judge of the Court of Appeals, the highest court in this state. Then he became a Supreme Court justice. They have a law school named after him. What he said in a case called People versus DeFora was, there is no blinking the consequences. The criminal goes free because the constable has blundered. All right? And that's the attitude of the judiciary. They're going to blame everything on the police. I don't care if this criminal really committed this crime. If the cop has screwed up, we're going to set him free. So you better know that. That's what you're up against. I hate it, you hate it, but that's the deal. Some of this presentation is geared more toward the drug field, so I'll skip over any slides that deal primarily with that. But the bottom line is, if you violate a person's Fourth Amendment right and you seize evidence as a result of your illegal conduct, that evidence is going to be suppressed. I mentioned that in most animal cruelty cases, you're going to need to get a search warrant. It's a safe thing to do. If you can get a search warrant, when you want to take property out of someone's house or off of their property, property meaning animals in this case, or evidence of animal abuse, you've got to, think about that. That's their property. That's their house. You've got to have probable cause to do so. Now, a lot of you police officers get consent to do this. That's one way around the search warrant requirement. We're going to talk a little bit more about that later. If you don't get a written search warrant, another way to do it is consent. Why this is up here for you police officers is to point out something that gets us burned all the time. Before you can even get consent to search, there's 4 levels of inquiry, okay? Police officers can ask different types of questions depending on how far they've come along in their investigation of a suspect. There's 4 different levels. That bottom level is easy. Request for information. Where are you coming from? Where are you going? What's your name? You don't have to suspect any kind of crime to ask those kind of questions. But that next level, common law right to inquire, this is the level that causes law enforcement the most trouble, because, especially in cases like this, where you want to get consent instead of get a search warrant. You cannot ask for consent to search someone's home or to search their property unless you've reached this second level. Okay, this is the first level. Easy. That's easy. Don't worry about that. Anyone can ask anyone these kind of questions, whether you're a police officer or not. It's the second level. Before you can get consent, you have to have a founded suspicion that criminal activity is afoot. Now, how do you do that? Well, there's a number of different ways. If you detect that they're lying, if they've given inconsistent stories or statements right to you, where are you coming from? I'm coming from Albany. Is that a toll ticket there? Yes, it is. The toll ticket shows that he's coming from Rochester. I don't know. Something to demonstrate that this person is lying to you. And you can articulate to a judge and to a jury how you know that. How do I know he's lying to me? Because he said 2 different things in 5 minutes. False responses. Combined factors. Is the person nervous, overly nervous for this, under the circumstance? All these things. You have to have a founded suspicion that criminal activity is afoot. before you can ask for consent. So please remember that. And if you law enforcement officers take anything from my part of this lecture, which is certainly subpart of Sue's, I want you to remember this. Consent stinks, okay? Judges in this county, particularly in Rensselaer County, don't like it. Judges anywhere don't like it. You may think you have a slam dunk on consent, but I'm going to say 6 to 7 out of 10 times when you have a consent case, our judges are going to say, nope, that wasn't good. Whether it's written consent, even if they sign a consent form, there's so many things that can lead up to that going wrong. And we're going to talk about that. I've got 5 uniformed troopers sitting right in front of me here. Do you think if even 3 of them went up to a door and knocked on it and asked politely if they could go into that person's house to search for something, and the person said yes, do you think that's going to hold up? Because if you do, you're wrong. If they're uniformed officers, all armed, even if they're polite as pie and the person is cooperative as can be, most courts are going to find that's coercive. And I don't like it, you don't like it, but that's the reality. If you're going to get consent, if you insist on disagreeing with me on that situation and you want to get consent, well, please, if it's okay, I don't want to screw around with your own safety as police officers, but if it's possible and you want to get consent, it's better to have someone who's not in uniform, who's carrying a weapon but it's concealed, and it's better to have fewer, okay? The judge will look more favorably upon a situation like that. And again, if you want to take my advice, if there's the ability to get a search warrant, please get a search warrant. I know for those of you that haven't done search warrants, it's a little intimidating. It's a court document, it's official, it's not, it's not something some of you are used to, but it's really not that hard. How many police officers here have written a search warrant? That's what I usually see. There's not many of you. But those of you who have, I bet have done it a lot. Every department has somebody who's done search warrants. And if you don't, then the department next to you or the barracks next to you has somebody. There are people in this room, I know for a fact, have done thousands of search warrant applications and know this stuff better than I do. The important thing is whether you've done one or not, make sure that you get someone to help you if you haven't, and make sure you know what you're doing. And my number will be up here. I don't care if you're from Dutchess County, call me if you have a question on search warrants. I love to help on these things because it's one of the few areas that I know what I'm talking about. So please, don't be afraid of them. They can be done very quickly as long as you have a cooperative judge, and you guys know that better than I do. But those of you, Skodak, for example, has a template, Skodak Barretts has a template for probably every kind of scenario you can think of. Talk to people that know what they're doing, and talk to people in their own specialties, too. We'll talk more about that when we talk specifically about the search warrant. I'm going to go through these quickly, but this is some of the classic stuff that police officers have found themselves in trouble with when they get to court. Where are you headed? Are you coming from? You can ask that before you have a suspicion of criminal activity. But all those other questions, do you have anything illegal in the car? Do you have any drugs or weapons? Do you have anything you shouldn't have? Those are all the questions you see the cops on Fox, on that cop show asking. They pull the car over, and before they do anything else, do you have any drugs on? Do you have any? That, in New York, you don't get away with. And if somehow you get consent based on the answers to these questions, before you've established that some criminal activity is afoot, then whatever you seize is going to get thrown out. That's why I don't like consent. It's dangerous. It's dangerous. Those of you that use it and know how to use it, it can be a very useful tool, but use it very carefully. This stuff doesn't really pertain. This is the third level of inquiry. Again, it's more directed towards arrests for drugs and other types of crimes. But finally, the most important level for purposes of our discussion today is the level 4, and that's probable cause. And this is the level you get to obtain a warrant. Here's the good news in animal cruelty cases. It doesn't take much to get probable cause, right? I mean, think about it. Probable cause to get a search warrant is no different than probable cause to arrest someone. It's the same probable cause. So if you've seen with your own eyes a malnourished horse, or if you have a neighbor complaint who says, they're obviously fighting dogs here, you've got probable cause. Look at what Sue talked about. She gave you a wealth, and some of you may not even know about the agricultural markets law You know, there's a wealth of crimes in that statute, in Article 26 of Ag and Markets. If you can show that any of those crimes are being committed, you have probable cause to search. It can be very, very easy. Use the Ag and Markets law, do what Sue did, and think outside the box. Criminal mischief, you know, I can tell you, I like to think that you know, we're a lot of smart prosecutors in my office, but I bet half of us wouldn't have thought to charge criminal mischief or grand larceny. Animals are property, that's true. And it's common sense. But use that, think outside the box. And remember, you're going to have to get other people to think outside the box, because you've got judges in Rensselaer County who aren't necessarily going to be used to that either. You want me to set bail on a felony criminal mischief for a guy who damaged a cow by doing whatever, pushing it over and breaking its legs? You want me to set bail on that? Yes, Judge, it's criminal mischief. Show to me how it isn't. You got to take an aggressive approach on these things. And with prosecutors, are there any prosecutors here? Okay, we got a couple prosecutors. Police officers have to get us to think outside the box sometimes. Some of you guys here, I wasn't enlightened, and I'm probably still not, depending on who you ask. But before I saw Sue's lecture on animal cruelty, there's a heck of a lot I didn't know. And there's a lot of you out there that do. So you're going to have to sell this to some of your prosecutors, too, if they haven't been schooled in this area. And I can tell you from my own experience that they haven't. A lot of them haven't. All right, just some things. I want to address the search warrant itself, because a lot of you who haven't done them need to know these things. Search warrants have to be signed, or can be signed, by your local court judges. A lot of you think that it has to be a county court judge or Supreme Court. It doesn't. It can be any local court judge. They have to go to the town with the jurisdiction, or a town that adjoins that town with the jurisdiction. So hopefully most of you know your geography, because that's going to be important. I've seen search warrants go down because some police officers go to the nice judge in the county, but that doesn't work necessarily. I want to talk about that too.
So Dan, can I just?
Yeah, sure.
If an incident occurs, say in Sand Lake, you would go to the adjoining town's judge.
Yes.
To apply for the search warrant.
Yes, that's right. And I live in Sand Lake, and I don't know that I know all the towns that adjoin, but all the police officers out there know your geography. Warrants can be signed by Superior Court judges too. What judge should you go to? This is something you guys know better than anyone, right? Here's what I don't want you to do, and I hope you don't, but I know the realities. There are judges in your counties and in my county that will rubber stamp a search warrant application, right? We know this. That's great for you, but that stinks for me. And I'm not going to go naming judges right now, but I can tell you that can be problematic. If you know you can get a search warrant signed and you take the easy way out by going to a judge you know is going to sign it, please don't do that. It's fine that they'll rubber stamp it, but make sure you've got a solid search warrant application and search warrant. Consider going to the county court judge in felony cases, and be prepared for some resistance there. I know that we have a couple cranky judges in our county who may not want you to come to them for an e-felony, but they may. And why I say that is, if you're going to do a suppression hearing down the road regarding the legality of that search warrant, or the appropriateness of the search warrant, isn't it better to have the judge who actually signed the search warrant decide whether he was right or wrong in signing the search warrant? It's going to, you know, everyone's got egos, but think about that scenario where a judge would have to say, I shouldn't have signed that search warrant. It doesn't happen very often. So if you're lucky enough to go to a judge who you know is going to hear the case, try that. But the bottom line is, don't try to take any shortcuts with these, because in any case, but in these cases, they are going to be litigated. Search warrant cases, even if they don't go to trial, a lot of times in my experience, I do know that because there's so many areas where a search warrant can have gone wrong, at least the defense attorney is going to want a suppression hearing to try to shoot that search warrant down. Because if the search warrant gets shot down, the evidence gets suppressed, you don't have a case anymore. That might be the final straw. If you win that suppression hearing, then maybe you don't have to go to trial, because maybe by that point, the attorney can talk some sense into the suspect. These are important facts, and those of you who have done a lot of search warrants know this. The big thing is, again, talk to people who have done it before. But location to be searched, you got to be particular. You can't just say 83 Green Avenue in Castleton, New York. What you should say is 83 Green Avenue, a duplex with tan siding and a brown roof. and encircled by a white picket fence. And describe, I mean, I can go on and on, but describe it as best as you possibly can. Judges like to see that you're careful, that there's no possibility that you're going to search the wrong house. Describe it particularly. Now, there's ways around mistakes sometimes, but I hate to have to get there because it can be very dangerous, arguing that they went to the wrong address, Judge, but it was described other ways, so they couldn't have made a mistake. That's an argument I don't want to have to make. I can win it sometimes, but sometimes I won't. So be careful. I like the idea of if you can lawfully take pictures of the place you're going to be searched, do that so that you have something to refer to when you're talking about describing this location. You can search people there, out, or therein. This is a very big problem, though, sometimes. You can search people there, out, or therein as long as you, in your application, put that you have probable cause to search everyone there, out, or therein. So, for example, you don't just get this for the taking, though. If you're in an animal abuse case, if you're going to a farm, for example, and you not only want to search for animals and evidence of their neglect or abuse, you also want to search the farm hands. Well, you better put in some reason why you want to search farm hands. They handle the animals, they care for the animals, or don't care for them. You can't just search farm hands because they're on the property. And that's a mistake that's made all the time, in my experience. Always got to have probable cause to search, and you always got to put it in the application. If it's not in the application for the search warrant, then forget about trying to argue about it later. When a judge reviews a search warrant and search warrant application for legality, they have to review it based only on what's in that application, the four corners of the application and the warrant. They can't call you up to the stand and ask you, well, what else did you have? It doesn't work like that, even if you did have a lot of other stuff. That's why you don't leave anything out in search warrant applications. Put everything you can think of that gives you probable cause into that application. Property subject to seizure. The big thing here, this is easy. I mean, look at the fourth one. Constitutes evidence or tends to demonstrate that an offense was committed or that a particular person participated in the commission of the offense. That's everything, right? Basically. You just got to put why, you know? And Sue has an example. She indicated it earlier in her discussion. The search warrant that she included in the later part of her packet is excellent. I mean, and if you go through that, you'll see. When you're drafting a search warrant application, if you've never done an animal abuse case, you really need to think about calling someone who has. Because, yeah, if it's a fighting case, for example, a pit bull fighting case or a dog fighting case, you want to seize the dogs. You want to seize obvious things like, you know, evidence that the dogs were injured. But don't you think that Sue's going to know things that you aren't going to know about? I didn't know about vitamins. I wouldn't have thought of that. You know, steroids, that spring stick, or I'm sorry, what? Spring pole. Some people that aren't familiar with this area of the law might walk right by that, or might not think it's evidence of anything. You know, you see it. I've seen it, and I didn't realize. You see a pit bull hanging from a tree, off those ropes. I didn't realize that's one way to strengthen them, train them, strengthen the jaws and the necks. That's something you want to take, right? So before you put in your application what you want to take, make sure you talk to an expert in the field. What should I be looking for, right? And make sure you include that both in the application and in the warrant. There's another benefit to this. We talked about all the other things that these types of cases can lead to. If you put in there that you're let's take a dog neglect case. If you're looking for a dog and you want to seize him because it's evidence of his neglect, well, if you only have that in a search warrant, you can only look for a dog. So if it's a German Shepherd, take the dog, but you're going to miss a lot of stuff that you could have otherwise searched for. You can't search for in a drawer for a German Shepherd. But if you put in there, you're also looking for documentation to verify whether or not this dog has been treated at a veterinarian. Now you're looking for documents too. You get into the drawer, and maybe you find drugs or you find evidence of other crimes. Maybe it's a little sneaky, but it's legal. You're allowed to seize things from places you're allowed to look. You can't go beyond what the search warrant says you can look for, though. So be creative. Make sure you get to look for everything, especially in those dog fighting cases. Because, you know, animal neglect, animal abuse may lead to other things, but certainly those dog fighting cases are going to lead to other things. Gambling go hand in hand with dog fighting, right? A lot of times so do drugs. People that involve themselves in dog fighting are also drug dealers, you know, drug users, gamblers. They're the dregs of humanity, some of these people. Think about who you're dealing with. People that get off on watching dogs kill each other. And think of the type of evidence you can get from that. And if you can't think of it, call someone who knows about these things. And that goes for every kind of case, every kind of specialty. Don't assume that you know everything you need to find is going to be in your application, unless you've talked to someone who knows what they're doing. It's a search warrant, it's a court document, you get a judge involved. Doesn't mean that you have to have more than probable cause all of a sudden. Sometimes you think that because it's gotten a judge involved, you better have enough there to say there's, beyond a reasonable doubt, there's evidence of a crime there. Because I'm going in front of the judge, I better have my ducks in a row. No, you have to just be able to show probable cause to believe that the crime is being committed, has been committed, or will be committed. Make sure that the stuff that you're talking about in your application that leads the judge to believe that you have probable cause is fresh. The information is fresh. So, for example, if you've got a neighborhood complaint saying there's dogs barking next door and it's got to be dog fighting, or I've seen that dog and it's skin and bones, that information provides you with probable cause, and we're going to talk about why they're reliable, those neighbors. But that provides you with probable cause as long as it's fresh. If you get that information on a Friday and you wait a month before you do anything, and in the real world that happens, right? You might have to backburn or something like that for any number of reasons. It's not going to be good if that information is stale. It doesn't mean you can't save it, though. Just go back to the neighbor and say, have you seen it recently? Yes, I have. How recently? 2 days ago. I saw it again. It's even worse than before. Get that in your application. Make sure your probable cause is fresh. And I see this happen all the time. One of the most common ways for defense attorneys to beat a search warrant is to argue that the information inside of it is stale and no good anymore. In animal abuse cases, it's not as much of a problem because if you see a dog that's skin and bones, it's unlikely that 2 weeks later that situation is going to change. But maybe a month later, as Sue demonstrated, or 2 months later, you saw the difference between that horse when it was neglected and 2 months after when Sue had gotten a hold of it. And I'm sure well before that horse looked a lot better. So you got to keep that in mind. Keep the probable cause fresh. I talked about the four corners of the application. The validity of the search warrant depends only on what's inside the search warrant application and the search warrant itself. Can't add to it. Talked about that. Here's the big thing, and one of the most important things. How do you establish probable cause? How can you do it? If you yourself, especially if you yourself as a law enforcement officer haven't seen what's the basis for the probable cause. Police sources, non-police sources, pretty self-explanatory. The big way you're going to get into cases like this, though, is information from others. And there's two types of informants. There's the nice informants, the concerned citizen informants, and then there's your snitches, right? And there's a big difference. Whether they're victims, witnesses, or criminal informants will make a big difference in your search warrant application into how far you have to go in showing that those informants are reliable. Okay. First thing, here's the good news. If you have a neighbor who reports abuse or neglect or something like that, and that neighbor is willing to go on paper and to sign a sworn deposition and give their name, they are automatically reliable. They've given you their name. They're subject to a crime if they've lied to you. They're reliable right off the bat. How do they know that that's easy to establish? They know because they're neighbors. They've seen what they've seen. And you don't have to go any farther than that. The problem, and it's not a problem, but the reality of the situation is there are going to be a lot of times, and we can all understand, when the neighbor wants something done, but they don't want to be identified, right? And in that case, you have to do this. You have to establish their veracity, their reliability, and you have to establish their basis of knowledge. And you want to protect them. In these dogfighting cases, sometimes you're dealing with dangerous suspects. You want to be able to have them be your probable cause and at the same time not be identified. So you bring them in front of the judge in camera. That's the best case scenario because then the judge can see for himself that this person is a concerned citizen, that the person actually exists. There's no chance of the police officer making this person up for their own benefit. And believe me, I know that's not fair, but there are judges out there who don't trust you. Police officers, remember that. You got to establish that. If they're a snitch, and I go back to this dogfighting case, Sue mentioned sometimes you get into those types of cases because you've got a drug informant who, in addition to being a drug user and drug seller, is also one of these idiots that goes to a dog fighting. And to get himself out of trouble, he's not going to just tell you about the one person he can buy drugs from, because that's not going to get him much of a break from us. He's also going to tell you about this dog fighting ring. In that situation, you've got to establish a track record, because he is almost as a matter of law a liar. He's out for his own best interest. You've got to be able to establish both that he's reliable and that he has a basis of knowledge. The basis of knowledge isn't so hard. He gives you a lot of information. On Tuesday nights, I go to this address, and every other Tuesday there's a dog fight there. All right? And then you try to independently corroborate that. You know, send an officer to the address. There's a lot of cars there. They're there for a short duration, or however long the duration is for a dog fight. I heard, I think yesterday, Sue said one of those dog fights astounded me. It took more than an hour. So I don't know. Talk to someone who's familiar with that and establish a duration. But independently corroborate the non-criminal acts, right? Not just you can't corroborate the criminal acts because you might not have a John Couch who can get into these things. You might have to just be able to corroborate what goes on outside the house, like you do in drug cases. You know, in drug cases, I see 100 cars go up there in a 3-hour space, and they're in there for a 5-minute duration. Well, what the heck are they doing other than selling drugs? Same thing, dog case, dog fighting case. A lot of cars parked outside the area, and they were there for 2 hours. That corroborates what the drug informant has said. You've also got to establish that something he's told you before has proven true and reliable. You've got to establish his track record. He's given me information in the past that has led to arrests. He doesn't have to have given you information that led to convictions, just information that's led to arrest. That's an important prong in establishing their reliability. Even if he's never given you information that's led to an arrest, you've got to somehow show he's reliable. If you can't, then you don't get past what's called this Aguilar-Spinelli test. So drug informants are typically your worst shot. But if you do it right, you can get there. We talked about all this. Here's something. And I should mention this because you've all run into this. What if you have two neighbors who have historically been at each other's throats? And we all hate these cases, right? Because they're impossible to deal with, prosecution-wise and investigation-wise. They're always accusing each other of something. And what if one of those neighbors suddenly now accuses their next-door neighbor of abusing their dogs or the kids or having dog fights? You know as a police officer that there may be some problem with that individual's reliability. Even if they're willing to give their name, even if they're willing to sign a statement, if that's the case, you've got to go further. You've got to investigate as to why you believe they're not lying this time. You know, why they're not just trying to make a gain for themselves. Those cross-complaint cases. I wouldn't even mention them if I didn't recognize how often they happen. Talked about this. Anonymous tips, useless, okay, in terms of search warrants. They're useless. That's not to say they're useless in general. Anonymous tips can lead to your investigation and other ways to establish probable cause, but don't bother putting in your search warrant as the basis for your probable cause that you had an anonymous tip. There's no way to prove the reliability. There's no way to prove the basis of knowledge. It's useless. Those hotlines are very good for giving you a starting point, but that's it. They don't have any use after that. I like to drill this into any police officer's head that I get a chance, especially the ones that haven't done it before. A lot of police officers, a lot of prosecutors too, especially prosecutors because they don't execute these search warrants, think that you get a nighttime warrant for the asking or a no-knock warrant for the asking. That is simply not the case. You have to establish in your application, remember the 4 corners of the application, that you need a reason to go in there after 9 p.m. and before 6 a.m. If you don't put in there why, then you don't get to do it. And a lot of judges, especially, predominantly local court judges, will not bother, addressing this issue. They'll just see that you're asking for a no-knock and a nighttime warrant, and they'll sign it. That's where you're going to get in trouble. Because if everything else is great, the search warrant is perfect, but you got a no-knock warrant and nighttime execution with no reason, the evidence is going to be suppressed. What a waste. You know what I mean? If you need to go in at night, or if you have to go in without knocking, there are lots of reasons you can give for that, especially for your own safety. You can think of a million of them. But put it in your application. In a dogfighting case, I don't want to announce my presence because that could get me killed. There's pit bulls in there. I don't know who knows. But put it in the application. Make sure you're safe, but just make sure you don't do it at the expense down the road of the search warrant itself. And notice authority, by the way, someone asked me, a police officer came up and asked me yesterday, it doesn't mean you can only get in if someone answers the door. It just means that when you have to give notice and authority, you knock on the door, you announce you're police, you give them a reasonable time to answer. If they don't answer, break the door down. It's not a no-knock warrant, but it might as well be if they don't answer the door. You don't have to wait for them to show up. You have to, if they ask for a copy of the warrant, you have to have it and give it to them. And sometimes judges nitpick this kind of thing. Make sure you have a copy with you, and it's better for one of the executing team members to have it right in their hand. I saw a case when I was researching this stuff where the officer had it on the scene, but it was in the car, and it went all the way to the appellate division because he didn't have it in his hand. Now, the good news is it turned out okay. But still, that's an issue you don't want to deal with if you don't have to. So make sure you've got a copy of the warrant in hand when you go to a search warrant. You don't have to give it to them unless they ask. Is there a reason why you just wouldn't give it to them, though? It's not like you're giving them the application, just the search warrant. We did a lot of this. I kind of jumped to this. What I have down here, though, is this email address here. It's the search warrant annotated by Judge Rosenblatt, who recently retired from the Court of Appeals. He knows more about search warrants than anybody in this state that I can think of. And that is basically a book. It's a search warrant. It's a complete search warrant annotated. It's probably 100 to 200 pages. All you do is download it off your computer, print it out, and I use it as a Bible for search warrant stuff. It answers every question I've ever had. And hopefully when you get back, you'll grab that, because he's a lot more articulate than I am when it comes to this stuff. I'll give you a minute to write that. Here's some of the exceptions to the search warrant requirement. The good news is, for probable cause, you need a search warrant, but the courts are kind of, I never compliment the courts because they're so hard on us, but this is an area where they give us some flexibility. If you have exigent circumstances, you don't need a search warrant. Be careful. I mean, I can sit here and tell you, go ahead and take whatever that property is, as long as you have exigent circumstances. But I'm not the one on the hook. You are. So if you have exigent circumstances, you better make sure they're really exigent. There's really an emergency, okay? Obviously, if anyone's in harm or there's immediate danger, and in some instances to an animal, you can argue, I suppose, although, again, some judges are going to be less inclined to expand the scope of exigent circumstances to a dog. I felt that in this case, that dog was in imminent danger of injury if I didn't go in. I think you can argue that's exigent. I think you'll get some resistance, unfortunately, from some judges who they may or may not agree with that. So, again, I'd love to be able to tell you, under any circumstances, go in, but I hesitate to do that because, again, it's not me on the hook. Hot pursuit, self-explanatory. Plain view. We talked about this. Once you're legally where you're allowed to be, you can seize any contraband that you see, anything that's evidence of a crime. Just make sure you're legally where you're supposed to be, and you're searching for items that you can legally search for. Plain view works out great in these cases, in these animal abuse cases, because, like we said, it leads to a lot of other things. You're going to find drugs. You're going to find evidence of child abuse in certain cases, as we have recently in Rensselaer County. You're going to find evidence of gambling. Just, use that plain view exception. Don't be afraid. I get calls all the time from officers on scene saying, can I seize this, can I seize that? Yes, the answer is, if you're there pursuant to a search warrant, you can see something pursuant to a legal search, then take it. I don't care what it is. If it has nothing to do with animal abuse, go ahead and take it, as long as you're legally there. The automobile exception. This is where I and the State Police Counsel's Office disagree. So I'm gonna make that qualification for a second, because I see there's a lot of troopers and investigators here, BCI. I said at the beginning of this search warrant talk, when you can get a search warrant, please get it. It's safer. I stand by that. I will say this, the State Police Counsel's Office, and they're just as smart, if not smarter than me, they say in this situation where there's an automobile exception, do not get a search warrant. You don't have to, and it's true. If it's an automobile, there's no requirement for a search warrant, because an automobile is mobile. There's always going to be an exigency, because they can drive away. I say there always is. I'm going to talk about that in a minute. If it's an automobile, you don't need a search warrant. If you have probable cause, go ahead and search. And using that example, we've all heard so much about this, where there's a dog suffering to death in a car that's too hot or too cold. That's a situation where clearly you can break the window and get the dog out if the car's unlocked. And you can tell them I said that if you want to. There's no question that that's an exigency. There's no question that you have probable cause. No question that a crime is being committed, because we have this agricultural markets law in addition to the penal law. There's no question under those circumstances there's probable cause to believe that a crime is being committed and that you can search that car and seize evidence. And incidentally save the animal, right? You're not going to get any argument from anyone on that. But there are cases where the animal may not be in imminent danger. I personally believe if you're proficient in search warrants, you can get a search warrant. It can't hurt. It certainly can't hurt, right? It's going to bolster the ability to get in. You're going to have two arguments now. You're going to have the automobile exception argument, and you're going to have the argument that not only did I have the automobile exception, but I'm an exceptionally proficient police officer, and just to be safe, I got a search warrant. State police maybe correctly argue that that might be setting a bad precedent. That's up to you to decide. You're the ones who are on the hook. Inventory searches are invaluable. You just have to make sure you have a policy, a written policy in your department that you follow. You can find all kinds of stuff pursuant to an inventory search that you would not originally have found pursuant to your regular search. But inventory searches are routinely held invalid if you don't have a department policy that is regularly followed. If you're a department here who doesn't have one, I'll write it for you. Just stick it wherever you stick your accreditation stuff or your rules and regs or your policies and procedures, and follow it. And I guarantee you it'll pay for itself in probably a week. Search instant to arrest doesn't really apply here. Obviously, you have the ability to search a suspect instant to arrest in their grabbable area. You don't need a search warrant to do that. Consent we talked about. Remember, consent stinks, right? That's the one thing I want you to take from here. And obviously, abandoned property you don't need a search warrant for. Some of this is pretty self-explanatory. And this is the definition, the legal definition of exigent circumstances. So you take that back with you, and you decide whether or not you have an exigency that justifies not getting a warrant. The only thing I may add for this lecture is a high risk of danger to someone. I looked, I can't find case law yet that says someone or an animal, but I bet in my legal opinion you probably could expand that. You're just going to have to be more careful, okay? Remember, their argument is going to be you're invading on someone's personal property. You're violating their rights to protect an animal. And depending on the judge you get, I can't promise you they won't be unsympathetic to that. The judges in Rensselaer County, I can say, are sympathetic to these cases. I've seen that with my own eyes. They won't hesitate to set high bails, well, one of them anyway, and they won't hesitate to put them in jail and actually advocate, not advocate, I shouldn't say that, they'll actually back you up. If an ADA goes in on a Buster Law case and says, I want prison on this case, some judges in your counties may not think that's appropriate. In Rensselaer County, at least, they're behind us on those.
Can I ask a question, Dan?
Sure.
And maybe Trish has an opinion on this. What if the judge made that call, that it was not admissible, but under Article 26, it is animal cruelty, it's plain as day?
Right.
Would that be appealed?
Yeah, oh yeah, you can always appeal. You can always appeal. And there is, and Sue points out, there is actually it went up on the screen, there is a section, if they've been neglected for 12 or more hours, is that right, or without food or water?
Right, more than 12 hours.
Right. So there's something outside the scope of a search warrant that gives you the authority under the Agricultural Markets Law to go in and take the animal. Just make sure you're on firm footing there. You know what I mean? Again, be aware of it, have it available for you, and be able to give whoever needs the explanation that you had the right to be there. Remember, this is not, animal cruelty prosecutions, investigations have been going on for a very long time, but they haven't reached the scope they're getting to today. So you're going to be dealing with people who are, A, ignorant, like myself before a couple days ago, to the Agricultural Markets Law, or B, unsympathetic. And you're going to have to get over those obstacles. And it's going to be up to you to do that. And us, as prosecutors.
I just want to interject something. You do need a search warrant to get the animals out of a situation where it has been for more than 12 hours.
Okay.
That does not come under
Okay.
It specifically states that under section 373, that a search warrant must be obtained.
Okay. Do you know, and I know there are probably police officers out there who have this question in mind. Do you know, I mean, I don't personally, I tried to find cases. Are you aware of any authority that expands exigent circumstances to animals as opposed to humans?
I just know that under the definition of animal cruelty, it's any suffering that's caused or permitted. I just would say that if an animal was being beaten or set on fire, tortured, just to stop that.
Right. Oh, absolutely, absolutely.
know.
A crime in progress, in other words.
Exactly.
Yes, yeah, there's no question.
Other than that, I would say we must get a search warrant to seize the property.
Right.
of the animals.
It's,
We have time.
right, right. It's the safest thing. And yeah, I should have mentioned that. Crime in progress certainly is going to be exigent. And those terrible extreme examples that Sue's seen personally, where dogs being set on fire or something like that, there's a lot of times common sense will dictate, and that's one of those situations that holds true. Pursuits, self-explanatory. We talked about plain view, the automobile exception, the state police slide. It does, both arguments, I think, are sound. You don't need a warrant. If you can, please get one, if you're in Rensselaer County at least. This is the inventory rule here. The only way you're going to be allowed to justify seizing evidence based on an inventory search is if you do all of these things. If you don't have a procedure, even if you do have a procedure, this has happened to me. I get a police officer on the stand. They have a written procedure in place. The next question is, and officer, you follow that procedure with every case? No, this is pretty much the first time I've ever done it. Then, you know, it goes out the door. So you've got to make an effort to enforce the procedure. That doesn't really pertain here. Consent to search, we talked about this. It's important. You need level 2 of that triangle. Found a suspicion that criminal activity is afoot before you can get consent. This is important too. There's a lot of confusion right now. In March of last year, the Supreme Court came down with a new case about this. Scope of consent. If you have valid consent, assume you get over all those obstacles I already talked about, sometimes you have 2 people. And it used to be, at least federally, it used to be that if one of the 2 people consented, you could search. The law is very clear now. If one of the 2 people that are present consent and one doesn't, you cannot search. If you have consent to search a dwelling where multiple people have interest in it, and one of those people gives you consent and no one else is there, hurry up and search. Because if someone comes back and says you can't search, you've got to stop. And the other thing about this that a lot of suspects don't recognize, so it doesn't come into play that much, is even if they give consent, they can always revoke it. What they give, they can take away. And you can't go tearing things to shreds. You've got to be reasonable. Their consent does not allow you to destroy their property, unless they consent to you to destroy their property. And I can't remember the last time that happened. Talked about all this. This is the last one, abandonment. Again, it's self-explanatory. You don't need to get a search warrant if clearly the property that you're looking to seize has been abandoned. And there's a lot of examples in your cases here, in animal abuse cases, where this will be the case. That's my numbers. I'll take any questions now, and anytime any of you want to call me on my cell phone, I'm on call anyway. Don't hesitate to call me. I'm willing to answer any questions about search warrants or search and seizure. As I said, that's one area I kind of have a pretty good handle on. So if you have questions, don't hesitate to call. Any questions now? All right, thanks a lot.